1-800-339-4885, 1-800-DeWitt Law. My name is Chris Crawford. With me is Moses DeWitt. He has been a practicing law in Central Florida for over 10 years now and been with the DeWitt Law Firm for that time. And we gather here every Sunday to give you and answer your legal questions and give you some legal thoughts on whatever's going around, if it's in Central Florida, in the world, and anywhere, really, if it's interesting. We'll kind of talk about it and relate it to something going on here. Of course, we'll give you a full update on the alimony bill here coming up in a minute. I know Mo did give us a brief update on that a week ago or so, but I missed that. I wasn't there for that show, and I need an update on this bill now. So we are going to chat with Mo about that. But in the meantime, if you have a question that you want to send into the show, you got to hit us up via email, ask@dewittlaw.com. That is ask@DEWITT law.com, and we'll answer some of your email questions on the air later on in the show. In the meantime, though, Mo, let's kind of kick things off here with something that was in the news this week.
Well, before we get to that,
okay, excuse me.
Where have you been?
Yeah, that's right. I was traveling. I went to Asheville. It was very, very nice. I went to school in North Carolina. I had driven like around Asheville, but never got to experience Asheville.
Did I approve this?
I think so. Yes, I hope so because I sent an expense report to you.
All right. I don't remember getting the time off request, but I guess I'll allow it this time.
Yeah, just make sure you handle the expense report.
So vacation?
Yeah, it was good. It was
nice.
It was nice. A nice little couples retreat up in the mountains, which was
very,
good.
very nice. Well, good to have you back.
It's good to be back.
You.
Yeah, and we got exciting things to talk about now that we're back. Of course, I do want to get the full lowdown on the alimony bill, but I want to start because I'm just curious, what kind of legal measures would somebody have if, I don't know, hypothetically speaking, they were at an award show and made some comment and somebody walked up, just out of the blue on stage. I know it's hard to imagine this happening, but somebody walking up out of the blue and smacking somebody on live television, broadcasted to millions and millions across America. Of course, hypothetically speaking, because that would just be wild if anything of the sort ever happened.
Of course, very, very hypothetical scenario.
Yeah.
I mean, it's a straightforward, simple battery case, right? It's an intentional, unwanted touching, which is a battery in the state of Florida and in most states. In this hypothetical case, Chris Rock did not want to press charges, obviously, and so most likely.
I don't think I mentioned any hypothetical names.
Yes, I mean most likely charges when battery cases or any sort of domestic violence cases. Typically, if the victim does not want to press charges, usually the state attorney or the prosecutor does not move forward with charges. And the reason for that is they need a witness to testify in court. And usually it's just those two people who were involved in the incident. Here, obviously, if the prosecutor actually wanted to press charges, they have hundreds of witnesses to do so, even if they didn't have the victim's cooperation. So technically, they still could. But my understanding is that in LA County, where this occurred, it's basically their policy where for simple batteries like this, if the victim does not want to participate, does not want to press charges, that they do not move forward with charges. So
could somebody be a witness that watched it on TV?
No, you have some authentication issues there.
Okay, I figured that was the case, but because it was live, I thought maybe that's something, even though with the delay.
But you could get the video into evidence if you had the camera operator come in to testify, to basically state when the video was taken, that's a true and accurate representation of what happened, and that had not been altered in any way with the raw footage. I assume they have the raw footage. You could get that into evidence to help prove the case, essentially, because it is on video. So therefore, you don't really need those witnesses.
But so there is a scenario in which case we could all be needed to go to court in Los Angeles.
The 2 million people get subpoenaed to testify.
If the video guy deems that the video is credible, and then they want to bring everyone in to be a witness in this case.
I don't see that happening.
I don't either. It seems like the only way this will end is with some Chris Rock jokes. But let's
Hopefully.
let's go ahead and talk about what has been pretty much the theme of the show for the better part of the last month or so, and that is this alimony reform bill, which we should know by now that it passed.
Yeah, which was surprising. It passed with two of the provisions in it, which we've been talking about, where it has a 50-50 presumption for child custody or time sharing, which basically means that when you go into court, there's a presumption that you have to overcome in order to get away from 50-50, away from equal time sharing. And as we've talked about before, that was one of the things in the prior bill that led to the bill not passing. So it was kind of surprising that passed with that provision. The other controversial portion of the bill and this is what led to the bill being vetoed previously under I think it was Governor Scott, was that the alimony, so it eliminates permanent alimony. Let me start there. You know,
Okay.
the bill eliminates permanent alimony. It puts a formula into place to calculate alimony, as far as the amount and the length, and it eliminates permanent alimony retroactively. That's the controversial portion of the bill. And so the question so right now, let me finish that. Right now, the bill is on the governor's desk to sign or veto. He has not taken action on it yet. So it has been passed by the House and the Senate, by the Florida legislature. We're now waiting to see what the governor does with the bill. If he vetoes it, like Governor Scott did, then the existing law will stay in place, and it'll probably go back in the Florida legislature in the next session. If he passes it, it'll go into effect in July. So that's where we are right now with the bill. The controversial portion, or the most controversial portion, in my opinion, is the retroactive nature. So what that means is basically it eliminates permanent alimony, not only for all future divorces, but for all past divorces as well, where permanent alimony was awarded. So the question is going to be, how does this play out in the courts? So do you file a modification and ask that the permanent alimony of your final judgment be eliminated and it be calculated under the new formula? The bill doesn't really say. So, in my opinion, the bill isn't really written very well, to be frank. And I think the reason for that is basically they just ran out of time in the legislative session. When we've been following this bill and talking about it, changes were coming very quickly, and it needed still a lot of reform at the end there, in my opinion. And I think they just wanted to get it passed, but they didn't have time to rewrite the bill to answer all these questions. So I think it's kind of a poorly written bill. Easy for me to say when I'm not the one who wrote it, but it's going to certainly, if it gets approved by the governor, I think it's certainly going to lead to a lot of litigation going forward as to how does this apply, how does this affect current divorces, how is this retroactive element applied to cases. But it's something definitely to watch. If you're currently paying alimony, you want to be paying attention to this because it could have a big impact on you, frankly.
Yeah, and I imagine that one thing that could happen out of this as well is that we see a clog almost in the courts a little bit.
Certainly, it could lead to that. Like I said, there's going to be a lot of litigation. We're going to see a ton of petitions for modification filed if this gets approved by the governor. The question that everybody who's going to call me is going to have is, how is it going to work? And my initial answer is going to be, we don't know yet. Because what's going to happen is this is going to work its way through the court system. Then it's going to go on appeal. And then that's how we're going to get the case law that tells us how this works. Because, in these types of cases, basically, there's two ways that we get told how something works. Either the statute tells us, which in this case, it doesn't. It's silent as to that. Or the case law tells us. The case law interprets the statute and kind of fills in the gaps, so to speak. That's the best way I can say it.
And so do we have a date or anything on when the governor's going to sign this? Is there a deadline that he's got to meet? How's that going to play out?
So I think there is. I think the deadline is in July, basically right before it goes into effect. I'll get the actual date. I don't have it in front of me. But if it were to pass, it goes into effect in July. So that's, if you're paying alimony, if you're paying attention to this, that's kind of your reminder date. Hey, check in July, see if this thing went forward, if the governor signed it, or if he vetoed it. If he does sign it, then in July, you're going to want to look at, potentially filing a petition for modification if you're paying permanent alimony right now.
Yeah, and I bet that there's probably a lot of people that are monitoring this bill right now. I think that that's something that would change a lot of people's lives, probably in a good way. I would say maybe save some people some money.
Well, it certainly could save people some money. Obviously, it depends if it's a good way or a bad way, depending which side of the
I guess that's
alimony
true, right?
equation you're
Yeah.
on.
Well, I'm thinking in the perspective of people who have been paying alimony for a very long time at this point.
Right.
It's kind of where I think that it would be helpful for, like, the ending of the permanent alimony for somebody who has been paying alimony for like 35 years or whatever, 30 years. It could be
Right. And now on the other side of the spectrum, obviously, the people who are receiving alimony may be relying on that alimony as their sole source of income. So that's why I say it depends which side you're on. I'm not favoring one side or the other, certainly. But one thing I think is surprising is that this bill made its way through the legislature, and I really didn't hear much about it in the media at all. Previously when the bill to eliminate permanent alimony was out there, I feel like there was a lot more press coverage of it. A lot of family law attorneys that I've talked to in town didn't even know this passed, didn't even know it was in the legislature this year, hadn't been following it. So I think it's kind of interesting how
it's
got
flown on the radar a little bit.
absolutely. I think it has.
I wonder how much of that has to do with just the fact that there is so much out there right now. Like there's news every day, so It
Yeah.
just could just be a oversaturation of everything else going on.
Well, I think it's partially that. I think it's also, maybe people just assume that it was not going to pass, given that it has been through there twice before and was vetoed or didn't pass. And so now, third time, very similar bill, just like, I opined, hey, this is probably not going to pass. And hey, I was wrong. Ultimately, it did pass. So maybe people are just not paying attention because they figured, nothing to worry about, nothing to really follow. This is just going to, fall by the wayside like the others.
Yeah, and at this point, we've seen it get to this part before, and we've seen it get as far as the governor's desk and then have it vetoed. So maybe that's also the thinking as well. Like, well, I've seen this movie before. I know how this ends.
Exactly.
All right, good stuff there, Mo. Appreciate everyone tuning in and join us here on this Sunday. Again, if you want to get in touch with the DeWitt Law Firm, you can go ahead and give them a call at 1-800-DeWitt-Law. That is 1-800-339-4885. And if you have a question maybe about that alimony bill, you're somebody paying alimony, it was a little confusing, a little, not as clear as you'd like it to be, well, that's our fault. Send us an email, and we'll be able to clarify it even better. Ask@DeWittLaw.com. That is ask@DEWITTLaw.com. We've got plenty more of the DeWitt Law Review coming up on WDBO 107.3 FM and AM 580.
This is my 2016 Harley-Davidson Fat Boy Low, all custom and all blinged out. This is Cruella DeVille. I am a district coordinator for Stilettos on Steel. We are a national female riding group. We support all sober, street, smart, safe riding. That means do not drink and ride. Don't drink and ride. If you're injured on the go, just call Mo.
Hey, welcome back to the DeWitt Law Review, WDBO 107.3 FM and AM 580, Orlando's News and Talk. Chris Crawford and Mo DeWitt with you on this Sunday. If you have a question for Mo, if you want to send us an email that we read out and ask live on the air, you can do that. Ask@DeWittLaw.com. It doesn't have to be about the topic we're talking about on the show. It can really be a general curiosity that you may have. Go ahead, send it in. Ask@DeWittLaw.com. Mo, let's talk about the other part of that bill there in the 50-50 assumption, because that is something else that is that won't affect prior instances. This is something that will now be put into play when dealing with children in divorces.
Right. So this is a prospective application. So it's not going to be retroactive like the alimony provision. But what it does mean is that when you're
Well, I don't even think it could be unless you could time travel.
well, no, I mean, technically, on a modification, if you petition for modification,
all right, never mind.
then it would have a retroactive
That's
application.
why that's why you're smarter than me.
That's right. But going forward, basically, there's a presumption for 50-50. So a lot of people out there are probably saying, "Hey, that sounds great. You start with equal time sharing," and I certainly understand that perspective. The people who are against this bill, who do not want this provision in there, basically say, now I have to show that 50-50 time sharing would be detrimental, which means out of the gate, I have to basically be very litigious, and it's going to make cases more litigious because it's going to be more of a scorched earth litigation approach, because now I have to show that 50-50 custody, would be detrimental to the child. So the standard before was best interest of the child. So the court's always supposed to do what's in the best interest of the child, and there was no presumption in favor of mom or dad. But for years, I have said, the days of dad getting every other weekend, those are long behind us. I haven't really seen that in the last decade, frankly. I always do say, courts, or in my opinion at least, most judges do kind of start with the idea that they want the child to spend, or the children to spend, as much time with each parent as possible. But they do look at what's in the best interest of the children when figuring that out, when calculating that. Now, it's a little bit different. Now they're required to start with 50-50, and then someone has to overcome that presumption. They have to overcome that burden and show that dad having equal time sharing or mom having equal time sharing would actually be detrimental to the child. So it's a different standard, and that may seem minute out there, but best interest versus detrimental is a very different standard.
That is very interesting. Yeah, and I guess the definition of what each one would be will vary as well.
I mean,
certain
you
circumstances.
basically have to show that one parent having equal time sharing would be harmful to the child. So
It does make it a more. It's like, yeah, because I think the way we talked about it, or I mentioned it before, me at least, it's like a game going into overtime being tied. It's like, here we go. You got this much time. You got to get it done, sort of thing. it does feel more pressure, and also in a way it could cause some like vengefulness. It could get ugly.
It certainly could, and then you're going to see a lot more allegations. Probably, a lot of divorces, for example, we see one party accuse the other party of alcoholism or alcohol abuse. And one of my favorite cases was it was actually the mother in this case had taken a cruise, and she had posted some pictures on social media of her drinking on the cruise. And opposing counsel had a field day with those and just showed picture after picture, trying to show that she was an alcoholic. And really, those pictures were all taken in a 3-day period, but they were just had more alcohol in those pictures.
Well, we talked about going to Asheville in the first part of the show. They've got a lot of breweries up there. So let's say you went on a couple's trip to go to the breweries, and you take a lot of pictures, or well, I guess it wouldn't be a couple's trip in this sense, but you
Right.
go and you take a lot of pictures at breweries, going in wineries and stuff out in Asheville, or maybe you go to Napa or something like that, and that could be used against you.
Absolutely. So, I think in litigation, if one party is trying not to have equal time sharing, trying to have a majority time sharing, then you're going to see a lot more of these accusations being thrown around. Now, we're pretty used to kind of advising clients on how to deal with that. But it does kind of make for a scorched earth, litigation on one side if they're going to try to not have equal time sharing.
And I imagine that these instances were kind of already happening before as well, where there were time, as you mentioned, you said you had a case where they did the cruise and the pictures and stuff. So if it was already happening, when you incorporate this kind of atmosphere, I guess you could call it, it's only going to make more instances of that, I believe.
Well, I don't know. I've always kind of said the cases where the parties really don't get along, where they're going to fight over every little thing, where they're fighting over the kids, those people are probably going to fight whether
Regardless. That's a good point.
They're going to fight whether there's a 50-50 presumption or not. It just changes the standard. It changes the burden that they have to present to the court in order to prevail. And that's ultimately what it is. It's not, it's whether time sharing would be detrimental versus what's in the children's best interest. Best interest just seems like a better standard to me.
It just sounds better too. Like
Sounds like a better standard. But in application, it'll be interesting to see how the courts actually apply this. And what we don't know, and what the bill doesn't say, is what does detrimental really mean? And that's where case law will come in eventually and tell us what do you have to show that it will be detrimental.
Right. Is detrimental like I'm a Colts fan, and my significant other is a Titans fan, and I don't want my child raised as a Titans fan. That will be detrimental to them because the Titans are bad.
If you
Well,
say so.
I'm just saying. I'm just like, it's my definition, right?
Well, I mean, I think it's easy
I
to
don't think
say
the courts would agree, but
Yeah.
it's just an example.
it's easy to say that drug or alcohol abuse, physical abuse,
Right. Yeah.
mental health issues. Those are all issues that are probably pretty easily fall. Excuse me, can't talk. Go under the detrimental category, where I think it's less of a clear cut issue is going to be what if the child's not doing well in school, or what if there's a lot of travel back and forth if the parents live an hour away, or the child's having behavioral issues. Those are kind of the grayer areas where we don't really know how are the courts going to deal with that. Does that qualify as detrimental or not?
Right. And again, I just agree with you in the sense that what's in the best interest just sounds better when talking with children. What's best for the children, not what's
Yep.
detrimental. I don't know. But that's just my perspective on that. If you've got a question about that, go ahead and send us an email. ask@DeWittLaw.com, ask@DEWITT law.com. We're going to get to your emails coming up in the next segment. If you want to schedule an appointment with the DeWitt Law Firm, you can give them a call at 1-800-DeWitt-LAW. That is 1-800-339-4885. Also, don't forget you can go online and submit a case evaluation there at DeWittLaw.com. We've also got past archive shows there. And of course, if you search the DeWitt Law Firm on Facebook, Twitter, YouTube, you can find videos of the shows on YouTube and Facebook and go past shows and kind of follow this whole alimony bill from the start. But you can also just kind of follow Mo and what he does with social media. It is a lot of fun. I promise you, you will not regret that decision.